GDPR has been around actually since 2013. That's when it was started with a committee in Europe, as all good things do, apparently, we're told. And it was enacted into law in 2016. So it's actually been sitting on the statute books since last year. This is the question you get most. Can you help me with it? Because I've just heard about it. I'm really worried about it. And the big thing is the change. The biggest change actually is that in the past we would have thought data belonged to us, the company that gathered it. This now says that the ownership stays with the subject. We are merely custodians of it. So that's got an impact, a big impact, on how we deal with data. No longer can we make assumptions. No longer can we consider it to be an asset that we can freely trade. Okay. Now, we'll also touch on the other bits of legislation because that's where it comes from. So, over the last 6 months, 18 months, there have been 6 major breaches from companies like this. Big companies, companies that you would expect to have very professional IT teams that would be ensuring that data is looked after. Now, if big companies like these can't protect it, then we need to really rethink about what we're doing. I mean, Tesco's bank, 9,000 records were lost. That's a bank, okay? If we look at it down the bottom there, it closed the hospitals in a health trust. They had to say, stop, no more admissions until we sort this out. So, what's the ICO say? What do they say about the responsibilities of companies now, and particularly the owners?
The new law equals bigger fines for getting it wrong. That's the obvious headline here. If your organization can't demonstrate that good data protection is a cornerstone of your business policy and practices, you're leaving your organization open to enforcement action that can damage both the public reputation and your bank balance. That makes data protection a boardroom issue.
So it's now a boardroom issue. It's something that's got to be thought about, just like your business planning, just like your business continuity plans. Okay. Now, 4 major credit companies that we use to do our credit checks, and their view of the impact on SMEs is this.
Hi, I'm Alice Pinch and welcome to Experian. Today I'm here with Jim Stephen, Head of Data Breach Response here at Experian. So Jim, how is the data breach landscape evolving for SMEs in the UK?
I mean, it's a really interesting area with SMEs at the moment. And that's really because the impact of a data breach to an SME organisation can really have a profound effect, not just from the actual direct cost being a higher percentage in cash terms, but actually the reputational damage, you know, even with a smaller percentage, if you like, of customers leaving, has a much more dramatic impact, if you like, on the top line and bottom line.
So what other impacts are there of a data breach on SMEs?
Well, as I say, they don't have the same depth within their organisation. They don't have big IT departments. So it's understanding that they're going to need to bring in specialist partners, but there's legal costs. And again, that reputational damage, but it's the impact on their cash flow that's particularly profound in that particular section of the market.
Right, thank you.
That's great. Thanks.
So, not just the obvious upfront issues, but it has an impact on your cash flow because your systems are down. So how are you going to conduct transactions? If you look at what effect a cyber attack has, the biggest one is on damaged reputation. Okay? So after damaged reputation, then it has an impact on revenue and productivity because you're having to divert all this extra effort into dealing with the breach. You have to take people off various jobs they're doing and put them on to other ones. Yes, you need to bring in the technical people to rebuild the firewalls, look at how you deal with your encryption, etc., and therefore 22% there. And then there's dealing with the ICO. Please, sir, or madam, we've made a mistake here, and we're really, really sorry. Okay? So it's coming. It's around the corner. It's next year. Oh, we've got plenty of time. But actually, there's things that you need to do before then. You need to look at your systems and decide where there are gaps and what you need to do in respect of them. UK comes basically from two pieces of legislation. The Data Protection Act back in '99, and the second one, this one here, Privacy and Electronic Communications Regulations. Now, most people will not know about that, but that's the piece of legislation that was driven by the debacle around the news of the world and the interception of various telephone calls and voicemails. But it also brought in a whole pack of legislation over marketing and how you do your marketing and how you deal with the information as a result of it. Now, they're being bundled up into this, which is GDPR. Now, some items of what we call PECR will continue, but others will be absorbed, have been absorbed into GDPR. Now, there's other legislation going through Parliament at the moment, and we'll talk about that later on. So what's it say? Well, the first thing, 25th of May 2018 is the effective date. And the ICO have said there will be no time extensions. We don't care what your excuses are. You've had 2 years, there will be no time extensions. So of that date, you will have legal responsibility for the custodial, safe custody of data. And as part of those regulations, they've fairly and squarely, like a lot of other legislation these days, put the responsibility on owners and directors. They've said, this is where it starts. If you don't set the culture, if you don't install the right policies and procedures, then this is going to come back and bite you. One thing, mandatory staff awareness training. Now, believe it or not, that is, under the Data Protection Act, a requirement. The very first thing that the ICO will ask you, if there is a breach at the moment, when were your staff trained and what training did they get? Okay. Audits. They will expect you to conduct internal audits to ensure that your data, your information is being correctly managed. Okay? That it's being gathered in the right way, that it's being stored, manipulated. And if it's shared, then there's extra requirements. But they will expect you to do internal audits to assure your own systems. They'll also say there is now a requirement for you to justify how you gather information and why you gather it. It's not just a good idea to have information. Why are you gathering it? Okay? They will also expect you to understand the rights of the people whose data you're collecting. Okay? So in the past, there's, yes, we know you're allowed that, and that. But this expands their rights. And you have to understand them because you'll be expected to explain it to the subject as well. Big thing now, which I alluded to earlier. You're going to have to design privacy into your systems. Okay? So when you think about buying a piece of software or a piece of hardware, or you're going to build a database, you're going to have to think about how can I protect this information. Where you think that there could be a risk to that information, then you have to carry out these data protection impact assessments. They're really no different to a risk assessment that you do already under health and safety. Okay? But this is something that you know you have to do. You also have to categorize data. They've now broken data down into two types. Personal data names, addresses, things like that. Sensitive data, anything to do with financial, health, criminal records, or can damage somebody's reputation. Okay? So that becomes sensitive data, something that you have to introduce additional measures to protect. Consent. That's the big question. What is explicit consent? Up to now, it's been great. You have on the bottom of your various invitations, various messages, a little paragraph, and it says, so long as you're happy and you don't put a tick in this box, then we'll gather this information and we'll retain it and we'll share it. No, that is no longer acceptable. In fact, it's specifically outlawed to have that type of box. You have to have now a box in which you put a tick in and say, I agree to this. Okay? Now, for some companies, they'll do a lot of business over the telephone. But they need still to be able to demonstrate that they've gained that consent. Now, if you've got a digital telephone system and you record all your calls, that will be sufficient. Otherwise, we're now talking about how do we get that? How do we get that explicit consent? How can I demonstrate that I have received that explicit consent from the subject concerned? So we're going to end up with electronic signatures, we're going to end up with physical signatures, we're going to end up with information, data, whatever you want to call it, that we're going to have to store and retain. Okay? If you're in the business that you have to deal with children or vulnerable groups, it becomes a little bit more difficult. Difficult because the rules say that you have to be unambiguous. They have to clearly understand what they're signing up for. Okay? So the language has to be very clear, very plain, crystal clear. Okay? You have to demonstrate that they have understanding. And you say, well, I've got permission from their next of kin or from somebody who has an enduring power of attorney. Enduring power of attorney counts for nothing except financial powers. Okay? Everything else, consent-wise, has to come from the individual. So if you're dealing with old people, people who've got dementia, very difficult. Very, very difficult. Data breach reporting. They've now categorized what you have to report, when you have to report. You not just have to report to the ICO, the Information Commissioner's Office, but you have to also report the breach to the subject concerned. So there's going to be requirements around the currency of information. You're going to have to make sure your information is up to date. You've got their current address, their current telephone number, their current email. So that if there is a breach, you can tell them. Otherwise, there'll be a civil suit. And finally, destruction and sharing. When you destroy data, a lot of people will know now, a lot of concerns around hard drives, a lot of concerns around fusion drives, etc. How do we clean them? Okay, now there are specialist firms who can do that for you. So before you dispose of a laptop, a piece of hardware, you need to make sure that that is properly cleansed. All right? More importantly, what do you do about the iCloud? How many people use the iCloud to store information? So how do you cleanse it? How do you know that information's gone from the iCloud? Is your supplier GDPR compliant? Is your supplier of your iCloud even inside the UK? Inside Europe? Where is it around the world? You can say, oh well, the storage is in America. That's not my problem. They're outside the jurisdiction. Forget about it. You are the custodian. So therefore, you're responsible for making sure that they comply, or you use a system that is compliant. All right? And when you think about emails, they can be stored on up to 8 different servers. One email can be split up and stored across 8 different servers. So it's really getting to know your systems, understanding them. Finally, when it comes to sharing, we're now talking about new legislation. We're talking about contractual arrangements. If you're going to share information or data with somebody, they're going to have to sign a contract that assures you that they will meet the same responsibilities. Okay? Sign here if you want to share data. Okay? You're going to guarantee me that the iCloud systems meet, that your policies and procedures meet, that how you use this information meets the original reason it was collected. And you can't share it unless you've got that agreement. So if somebody says, I'm going to let you have my information for the purposes of recruitment, if you're going to share it with somebody, they can only use it for those purposes. And if they have agreed to it, share it. Today, that's the question that is most asked of companies. Who are you sharing my information with? Now, remember what we said about you have to have the opt-in box? Well, that little thing on the bottom that you agree that information will be shared with a third party, that goes out, okay? Yes, they can sign it, but you'll have to also put in the fact that you are going to ensure that whoever you share it with meets the GDPR, okay? And they'll not use the information for other than what it was gathered. So, most companies at the moment have somebody, nominally, who's called the data protection officer. And it's usually at the bottom, right at the bottom of the job description, just before as any other duty that we define you need to do, all right? If you're an SME or a micro business, the owner goes, I'll do that as well. However, they've said now that you must have a DPO if you have information on more than 5,000 people. Okay? So if on your network base you have more than 5,000 people, you need to have a designated DPO. That includes your smartphone, if it will hold up to 5,000. And with the microcards, etc., you can get these days, that's not inconceivable. So if you built up a network of 5,000 people or more, you officially have to nominate a DPO. They say it's advisory for other businesses so that they can keep themselves up to date and accurate with what's going on as developing. And the reason for that is there's a committee called it's called Article 29. EU love this. Let's have a committee. Oh, we'll call it Article 29 or Article 53. And the Article 29 committee will keep this legislation live by going through and revising it, reviewing it, and issuing new policy on a regular basis. So this is going to be live legislation, very much. It's going to change. So you need to keep your eye on it. What they also say is the DPO is supposed to be independent. You're employing this person, but they've got to be independent. Okay? Now, in the very biggest of organizations, there's talk that they may bring in an external company to do that role, to demonstrate the independence. Otherwise, the person who's the DPO is going to have essentially some form of authority written into their job description that they can rove around the company, that they can make recommendations direct to the owner on measures, on steps they need to take in respect of data protection. They'll also have to do some sort of training because they'll have to understand what their firewalls, what their hardware is capable of producing in respect of encryption and defeating attacks. The other thing is that this is trans-border. Because it's EU legislation, it applies throughout the EU. Okay? And what they've said is, if you carry on data processing operations beyond Northern Ireland, beyond the UK, even in the Republic of Ireland, then you have to think about that. And if the majority of your transactions are outside the UK, then you have to report to what they call a supervisory authority, the multinational ICO. So another company, argument's sake, say you did 62% of your business in the Republic of Ireland, well actually you would report to the supervisory authority down there. If there's a breach, you have to tell them. Okay? So, breaches. These are the 5 key areas where if there's a breach, you have to tell the ICO or, as I said, the supervisory authority. So, if it affects somebody and it can lead to any of these 5 types of action, then you have to tell the ICO. And you have to tell the individual. Okay? So you remember we're talking about that assessment right at the beginning? When you look at information and you do an assessment on it, you say, if we get a breach, this is like what it's likely to cause. So if it causes any of these, then it's a reportable incident. How do you assess reputational damage? Is it going to affect somebody's reputation or not? It's a call you have to make. Always err on the side of caution, all right? Last thing you want is, a couple of years down the line, so a letter from his sister landed on your desk saying, you know, you've damaged my reputation, as a result I can't get a job, or my company has lost business, and we're looking for this in respect of reparations. We talked about Tesco Bank earlier. This is what the breach cost Tesco Bank. All right, that one breach, 9,000 people, £2.5 million. That's what it cost them, just 9,000 people. So it's not that far beyond a medium-sized business. The worrying aspect is this. These are the costs here, the £2.5 million. The Financial Conduct Authority is yet to decide on their fine. It's estimated it's going to be 1.9 billion. 1.9 billion. That'll put some businesses out of business, won't it? You think about the scale of that. Over 10 times what they lost, what they've paid out already. So it's going to be a good business decision to spend time, to spend money in looking after your data. Well, it's not your data, remember, you're just the custodian of the data. So, what sort of other sanctions? Under the GDPR, the sanctions are going to be this. If you're naughty boys or people, and you could demonstrate that you really did mean it, that it was really an accident, you'll get a written warning. Okay? But only in the first offence. You will also be subject to regular external audits. Okay? You may even have a restriction placed on you in respect of how you handle data or process it. What impact is that going to have on your business? They say, stop processing data, or you can only do this with data. Or, on an unannounced basis, our auditors will drop in to look at your systems. Oh, stop. Hold on, we've got to deal with this person. We've got to show them what we do. Worst case scenario, the fines. Okay? So, in respect of the obligations you have as a data processor or a data controller, 10 million euros, or 2% of your turnover worldwide. So if you have worldwide business, they can choose to take 2% of your worldwide business turnover. Turnover, not profit, turnover. if it's in respect of how you've processed information, or you've contravened somebody's rights, or you've transferred data without permission, or you have notified them of something, 20 million and 4% of your worldwide turnover. And just emphasize again, turnover, not profit. Okay? So, why? Why does it pay to take notice? Well, this is why. Because just reported last year in the UK, 6.4 million was lost to cybercrime by businesses. Okay, doesn't sound much, but how many businesses actually report it? Because it has this impact on their reputation. Are you going to do business with somebody that you don't trust, that's not going to look after your information? Large businesses, 80 attacks per annum. 80 attacks per annum. One every 4 days. It's actually more, one every 3 days if you look at the working week. And 30% of those breach their security. Now, that may be their firewalls, it may be their antivirus, it may be their malware defense, but 30% they breach. Now, research shown that 55% of staff have no training in how to deal with cyber attacks, okay? And the majority of people are very, very worried about how they deal with emails. I think most people know now about phishing. You know, don't open an email, don't press this, because it's going to let a piece of aggressive software onto your system, and that system can then be defeated by it. It'll record keystrokes, it'll transmit the keystrokes. So information will be passed out on a live basis as to what's going on in your system. Some, like the ransomware attacks that we've seen, just freeze your computers. Your whole system stops unless you pay this money. And 80% of people are paying ransomware. They're paying off the ransomware because the complexity of the information, the complexity of the attack, of the system, of the worms and the various things they're using is such that it can't be broken very quickly. We're talking, it may take weeks. And that's if you've got the resources to do it. So they pay. But the best thing is, don't let it in to begin with. Now, if you train your people, 80% of them say they feel more confident, able to deal with those threats, okay, and respond to an attack. They know what to do so that it defeats the attack to begin with. The other thing is, you spend that time on it, it reduces any time you have to spend on subsequent investigation, because they know, they see things wrong, they record it, they take down the information. That information is then available either to your corporate IT, your IT wizard in the team, or to pass on to the cybercrime units. Okay? So this is what the Director General says about attacks in cyber. Now, the British Chamber of Commerce recommends 3 things. They say, put in place proactive cybersecurity plans and procedures and include staff training in that. Look at accreditation for your system, some sort of benchmark. It doesn't have to be 27,001, which can be expensive. You can look at 27,002, which is an internal quality system, which it does exactly the same thing. And they also say, do regular assessments of your information systems. Okay? It's 3 simple steps that will help you deal with this issue. Now, if you do that, it should reduce any cybersecurity attacks you have, and more importantly, the breaches. That's what we're interested in. You're going to have attacks. It's the breaches you want to deter and prevent. It'll stop the damage caused by an attack, and it'll increase confidence amongst the business about how they deal with it. And if people are confident, then they're not going to spend time going, what do I do here, da da da. They can get on with their work. All right. So the legislation, we talked about the DPA, we talked about PECR, we talked about GDPR. This is the Data Protection Bill. It's just gone through the House of Lords, and this will come into effect next year. And it supplements GDPR. Okay? So what it's going to do, it covers the areas that GDPR hasn't. It's going to cover things around legal investigations, procedures. It's going to avoid prejudice of criminal investigations, anything in relation to prosecution and sentencing. It'll also look after public security, national security, and it'll look at the protection of rights and freedoms of people. It'll also introduce measures to govern automated decision making. Okay? So if you have some sort of system, you've put data in one end, and your system crunches it and produces decisions at the far end, then it will say that has got to be controlled. Okay? It's going to be interesting because it's going to pose problems for large companies doing recruitment who have to do SIFs with computerized selection. Okay. Right. So, if you want to get safe online, here is a free resource. Here. Okay? Gives you information, gives you advice on what you can do. If it gets to the dodgy end, it gets to the bit where you think, I am being attacked here, two units. TSI cybercrime unit and action fraud. Now, both units are seriously under-resourced. The PSNI cybercrime unit has only 30 officers in it. That sounds okay, 30 people. 90% of them are engaged in dealing with, how do we put it, simply, child protection. 90%. So only these 3 officers do the rest. Okay. Action fraud, they will look at it, they'll say, well, how much is the damage? Is it worth us getting involved? We've only got so many officers. Okay. So the big thing is going to be, turn around, look at yourself in the mirror, because that's the person responsible. All right? That's the gallop. Okay? So, if you have any questions, have we got time for questions?
Yep. Alex has a microphone, so if anybody's feeling brave enough to be the first to put up their hand.
Go. Not allowed to look at you.
I'm just curious about the verbal consent. Is that okay, and does it have to be gained periodically?
Verbal consent, you need to have it recorded. Whether it happens to be a digital telephone system or some way of recording it. All the information, in fact, you're supposed to, part of your audit system, reconfirm consent on a regular basis. Regular being at least annual. Okay? If you don't confirm it, then essentially you're holding data without people's consent. Okay?
I thought it was interesting you were saying about the recording of the phone calls.
Yes.
So how do you get permission before you record the phone call to get permission for it?
This is where your privacy notices, etc., come in, and you start the phone call with basically a standard text. You know, this is why you're hearing on your phones now, nearly all digital systems now, you're hearing that we record your calls. Okay? What they need to add to that is if you do not wish your call to be recorded, you may put the phone down now.
Yeah, I understand that. Just sounds like a bit of a blackmail, because if I'm trying to get through to BT to fix my phone and they
Yeah.
say call may be recorded, well, if you don't want to record it, you don't have a choice, you just need to get your phone fixed.
Uh-huh. But it's also good protection for you.
It just sounds like a bit like the take this to, you know, if you don't agree,
Aye.
that message at the start of
Uh-huh. But it's your protection as well, because if you're ringing them and you're saying, I want to change my contract, i.e., say Sky or somebody like that, you know, how often do people actually not do what they're supposed to do? How often do you end up going back to them and saying, I rang you on a certain date and I thought we agreed to do this, and now you're still charging me for something else?
With regard to sharing of the information, so we used the recruitment agent as an example. So I've given permission for my data to be with the recruitment agent, and then they share that with particular companies.
Yes.
And the onus, if I go back to the recruitment agent and I want, that's my data, I want it removed,
Yes.
who's then on the onus? Do they have to notify everybody they shared it with and they have to remove it as well?
Yep.
Or do I have to go to everybody that was shared with to ask them to remove it?
No, your relationship is with the person that you initially shared your data with, okay? And if you, one of the rights is that you can have your data removed, okay? So you can ring up and say, what information have you on me? Da, da, da. They say, we've got this. You say, I want that now scrubbed. Now, on the contractual thing, I remember I said about contractual. If somebody shares data with somebody else, there has to be a contractual agreement, and they have to meet, as a minimum, your standards of data protection. How you gather it, how it's stored, how it is maintained. I said, if you ask for it to be destroyed, that it will be destroyed. There are circumstances in which it won't be. If it has to be retained for legal requirements, so argument's sake, say it was a billing system, and you were issuing invoices or taking money from somebody, well, that has to still meet the requirements of HMRC. So you're holding you'll continue to hold that data for up to 7 years, or possibly 8 years. Okay. If it's health, it'll be retained because obviously you've got a health record, and how people deal with you, you know, that may work. Now, if it was a health insurance company, they would have to remove it. But if it's somebody, hospital, GP, health professional, they can retain it. Obviously the police, anything to do with an investigation. Now, some information can be retained for up to 75 years. And that's in, for example, foster care. Because children have the right to find out who were their real parents. Okay. If you're in that sort of business, then you're up to keeping records for a long time. Does that answer?
Yep.
Take this one and then we'll come to you.
We've got a number of clients. We use third-party systems for managing their data. Now they own the data, but we will dispatch emails and manage their data. If that's a third party like Campaign Monitor or Salesforce, does the responsibility lie with the client we work with, or does it lie with us?
Lies with you.
Lies with us.
If somebody gives you information initially, you are called the data controller. Other people who you subcontract or have commercial relationships with become data processors of that information, but you are the controller.
Steve, just follow up on that point you made a minute ago. Health insurance companies, I mean, I take it parents can contact health insurance companies and say, what information you've got about my kids and what do about it now?
Yep.
People might move from one company to another.
Yep.
Okay, thanks. The second one, we have clients that are groups of companies, so one in particular has a holding company, maybe has a dozen subsidiaries all across the UK and Ireland.
Yep.
What implications are there for that organisation where they maybe have shared data freely between the various businesses on the assumption that we're all one company here. Particularly I'm thinking in terms of submissions to pension companies about contributions or insurance companies about other employee benefits, that sort of thing.
Well, up until Brexit, information can be shared, okay, so long as they've got the initial authorization from the subject, and they've made it clear that this is with other companies in their group they're sharing. The complication will be with where the weight of data processing takes place, and if it's taking place outside the UK, then they're going to have a second supervisory authority to deal with. So they'll have to go, say, if 60% is done in France, for argument's sake, or ROI, they'll be going straight away first to the supervisory authority there to say we've got a breach. Okay. Now, GDPR is what we call baseline or enabling legislation, so countries can add their own layers on top. So if you're operating in another country, you know, they may decide to put another layer on top, and you have to be aware of that.
What should you do if you feel that a company isn't actually handling your details and adhering to GDPR regulations?
Well, the regulations have full effect from 25th of May next year. However, Data Protection Act says that they have to protect your information. And if you feel that they're not handling your information correctly, then initially you go to the data protection officer in that company, you make a subject access request, and they will then tell you their policies and procedures and what information they've got on you. Now, the difference between Data Protection Act and GDPR is that you'll pay for that request under the Data Protection Act, but under GDPR there is no fee. So somebody makes a request under GDPR, you're not going to get 10 quid, you're not going to get 15 quid, you just comply. Okay? All ready to go? Any more questions? Okay. Well, as I say, Get Safe Online, good place to look. The ICO also run a blog. It's up, and they run a myth debuster, and they're up to, I think, number 8 at the moment. But that on a monthly basis, they issue various little bits to their blog and say, this is what people are currently asking us, and it's a myth. Okay. GDPR is really no different to what you do with health and safety and various other things. It's asking you to assess the risk and to take appropriate action to prevent a breach. And one of the things about it is that there's a thing called, no, I get my name right, get my anonymization, all right? Okay, so if you're holding information, a database, it's not just sufficient to have antivirusware or a strong firewall, but you need to encrypt that information. That's where BT Talk went wrong. As soon as they got through the firewall, they could see all the information. So you need to think about encrypting sensitive information or information that you regard as commercially sensitive. Now, do you want people really see all your customers? How to get in contact with them, how big their accounts are? Okay, because you've gathered that. You spend a lot of time networking and getting their confidence and getting them to work with you. And if people can get in through, and let's face it, when you've got 14 or 15-year-old guys who are breaching the National Security Agency in America, the whole thing has got to be then, what do you do behind that? And encryption's the answer. Okay? Sure.
Thank you. First and foremost, thank you, Stephen, for that presentation. I'm not sure if it's been more informative or more daunting for everybody in the room. I think you can probably understand why we've now got Stephen in helping us with our systems and processes. Apologies as well, we've overrun slightly, but you can see it's a major subject matter and there's a lot to get into. So from my perspective, I just want to thank you all for coming today. In your seminar booklets, there's a 12-point action plan that you can take away and bring back to your businesses just to review. If you're wondering what the plastic white things are in your folders, anybody's looks, these are mobile phone stands. Does anybody know they're mobile phone stands? And as I say, just to thank Alex and the guys from my team for helping out with today. I hope you found it informative and enjoy the rest of your day.